Can you hear me now?
Yeah.
Okay, cool. So I won't use that now. Again, my name is Lance Rogers. I've been a lawyer specializing in stuff for about 3 years now. I hope you don't mind. I'm going to put on my sunglasses. Eugene asked me to talk about the history of medical marijuana in the city of San Diego. I thought I'd go back a little bit farther and talk about the history of marijuana in general. Believe it or not, marijuana's been illegal, was illegal in the United States for only 30 years. And when you think about the history of the U.S., and you think about the history of the world, and how long people have been around, how long marijuana's been around, that's a very small amount of time that we've actually lived in a prohibition era. You heard the gentleman with the OB rag talk about 1976. That's when the Controlled Substances Act put marijuana as a Schedule I substance right alongside meth and black tar heroin. We've been fighting ever since to reschedule it that level of substance means that it has zero medical value and is highly addictive in the eyes of the federal government. And that's true today. The federal government believes that marijuana is on the same level as black tar heroin. But going back, marijuana has always been around. It should be no surprise to anybody to know that marijuana is a plant. It's grown. It isn't made in a laboratory or something. You can put a seed in the ground and it can grow. And it can be grown for hemp, like you heard that gentleman say. All the hemp is illegal in the U.S. too. And I'll go in different tangents, and you guys can ask me questions. I have to fill some time here. So hemp too. All of the hemp that we eat, if you've gone to Trader Joe's or Whole Foods, all of that is imported from China and Canada. They mark it up about 30% because, hemp is illegal in the U.S. as well. But again, marijuana wasn't always illegal. It only became illegal in the 1920s or in the Marijuana Tax Act. Interestingly enough, during the prohibition era of alcohol, prescriptions for whiskey shot up. So you would go to your doctor and say, I have a cold and alcohol is illegal, so I'd like to use whiskey. And that's when Walgreens actually became a big household name, was dispensing whiskey for headaches and things. But from the periods of the 20s to the 50s, it was around. It wasn't as illegal as it is after 1976. 1950s, obviously, we had something called the reefer madness, which was all right. Interestingly enough, this past year in 2011, they made medical marijuana for dogs. It is possible. Again, your dog can't die from marijuana either. Somebody at Americans for Safe Access, their dog ate some and he just got a little sick. But you can buy that in some states. In any event, 1950s we have something called reefer madness, which is documented. We heard somebody talk about the hemp industry. There is documentation to support the fact that it was this concept that was put out in magazines that marijuana causes people. Interestingly enough, it was focused on the Latino and the African American community. It made those people get really crazy and rob and do things like that. And there is documentation to support that this was an effort to undermine the hemp industry because we wanted to focus on the cotton and the other textile industries and push out hemp. In any event, we had this concept that marijuana will make people crazy and do outrageous things. No science to support that, but it was put out by the government in the 50s. Then you get into the 60s and 70s. And it seems as if a reaction of the 60s and 70s. In 1976, we have the Controlled Substances Act. And it is interesting because in 1966, I would have loved to have been a part to try and legalize marijuana. And unfortunately, it seems that in 10 years, instead what we got is marijuana as a Schedule I substance, as I told you about, which is on the same level as black tar heroin. For 30 years, marijuana was always illegal. No ifs, ands, or buts. In all 50 states and the federal government, marijuana was illegal. Schedule I substance, no medical value, highly addictive. 1996, the good people of the state of California, of which we all are citizens of the state of California, we're also citizens of the United States, but again, under the 10th Amendment of the Constitution, there's states' rights and then there's federal rights. And people always are fond of saying, well, a supremacy clause, that means the federal government always trumps, right? Well, not always. You know, there still are states' rights, and there is a concept that states should be allowed to be a laboratory for new ideas.
Yeah.
We try things in states, and then we see if they work. For example, one of the things that seems to be working is the concept of medical marijuana, because since 1996, when we in California passed it, 16 other states and the District of Columbia have passed laws decriminalizing marijuana for medical purposes.
Right on! Yay!
Next year, there are 3 other states that are considering such actions. However, again, as everybody knows, marijuana remains an illegal substance. A marijuana seed is a violation of federal law. Okay? In 1996, we passed this law called the Compassionate Use Act. It received overwhelming support from the voters of the state of California. It was a voter initiative. What it did is it decriminalized possession and cultivation of marijuana for medical purposes.
Yeah.
That was revolutionary. It changed the history in regards to marijuana. It was the first time that people could legally or have immunity from prosecution for possessing and growing this plant for medical purposes. Again, possession and cultivation of marijuana for recreational purposes continues to not be legal. It is only legal for medical purposes.
Right on.
Specifically under the law in California, we have a very liberal law. In some states, you can only use marijuana for very significant things: cancer, HIV, glaucoma. You know, I'm sure some in the group would qualify. We have those in California, but we also have a subsection of California law that says for any other illness or injury for which marijuana provides relief. And this is really sort of a policy discussion. A lot of times you hear opponents say, oh, well, anybody can get a marijuana card, it's that easy. Well, it's not supposed to be that easy. You go to a doctor, and the doctor, using his medical degree and his training and experience, like Dr. Greenwald was saying earlier, can make a determination that somebody can benefit from the use of medical cannabis. For example, anxiety, PTSD, chronic pain. These are all things that aren't listed, but they are things that doctors and the California Medical Association, as well as the American Medical Association is still contemplating it, have decided that medically, and these are doctors who are qualified to make these opinions, medically, marijuana can provide relief to these things, okay? Right. So again, I'm fond of being in court or in the city council or in public rooms, and people always go, oh, well, I don't think you can use it for anxiety. I think it's bad. Or I don't think you should be able to use it for PTSD. Where's the science? Where's the science? Well, again, I always want to remind people that doctors are the right people to make these decisions, not policymakers. Doctors go to medical school to make medical decisions. It's not for the rest of us to say, well, I don't think that you're sick enough. I don't think that you're in pain enough to benefit from this medicine. That's for people's doctors, and that's a conversation between a doctor and a patient, which is private, which is up to them. In any event, 1996 to 2003 was kind of a hectic time because the state of California had to try and figure out all the things that this meant. In other words, how much can somebody possess? How much can somebody cultivate? Can you transport? Where do you get it? And honestly, we're still trying to figure this out. Where do you get marijuana? For example, we're in the city of San Diego, and we're in a politically controversial time. It should be no secret that all of the elected officials in our city, in our county, don't want medical marijuana patients to be able to get marijuana anywhere. They've sued, well, in descending order, I guess, through chronology. First of all, the county banned dispensaries in all but one location throughout the entire county of San Diego. The city passed an ordinance that said all dispensaries must close for a year, and then we'll think about giving out licenses. And then since October 4th, the U.S. Attorney, and all 4 U.S. attorneys throughout the state, have initiated what's been called the federal crackdown. and have sent letters to over 200 dispensaries throughout the Southern District of California, and have raided many people throughout the county as well. This is an all-out war on drugs, to use their word. This is a war on medical marijuana, for which the people of the state of California resoundingly say that we should have access to.
Yeah!
So what's going on here?
215!
In any event, in 2003, the California legislature decided to clear up the law a little bit. They decriminalized a couple of other things from the list. They decriminalized felony cultivation, felony transportation, felony sales, and felony possession of sales.
Yeah.
So we're still trying to figure out what this means in court. I think that it means that people get to cultivate, transport, and buy marijuana. There are other people throughout the state and many in law enforcement that say you cannot buy marijuana. We're still trying to figure out where you get it from, but there seems to be this concept that the only thing that people can do is grow it themselves, or have sort of 2 or 3 people who will grow it all together and no money is exchanged hands. The problem with this is that seriously ill Californians, the people for whom the law was written, many times are too sick to grow marijuana. Marijuana is difficult to grow. Additionally, most people like to buy medicine in a store that is safe and clinical, that has things like keeping patient records safe and security and privacy. They don't want to just grow it themselves or buy it on the black market, for that matter. I guess that's the other alternative, is you could continue to buy your medicine from the black market. This doesn't seem right. This doesn't seem reasonable. We've had a number of court cases since 2003 to try and figure out how these laws work. These laws are still being developed every day. Okay, focusing, I guess, on the city of San Diego. In 2008, the Narcotics Task Force, and if you're not familiar with that term, then you should be, because it has a big presence in the county. The Narcotics Task Force is a group of cross-sworn law enforcement. They include the San Diego Police Department, the San Diego Sheriff's Department, the DEA, the U.S. Forestry Service, the FBI sometimes, the Bureau of Alcohol and Tobacco and Firearms. And so they are an agency of local law enforcement and federal law enforcement. If you've been listening to me, you understand why that's problematic. Because under federal law, a marijuana seed is always illegal. Under state law, a patient, and we can get this if you guys have questions, may possess up to 6 mature and 12 immature plants, up to 8 ounces of marijuana, or if you want to look at the law in its most up to the minute form, an amount that's reasonably related to your illness or injury. So under federal law, you can go to prison for possession of a pound or an ounce, even if you had priors, of marijuana, or even a marijuana seed if you were going to be charged. Under state law, you're immune from prosecution for, at a minimum, possession of 6 mature and 12 immature plants. So we have a conflict of laws, and when one police agency tries to enforce both of these laws, you end up in situations where normal people are looking at, feel like criminals. I see criminal, criminal, criminal all over the signs. This is not just melodrama. This is not just for the cameras. This is real. In fact, there are people in our group right now who are being prosecuted as felons because of following state law. And that just doesn't seem fair. This is a civil rights movement, and it doesn't make sense at the end of the day. So cases. In 2008, we had, can't remember the name of the operation. 2009 was Operation Green RX. 2010 was Operation Green Dope. I can only believe 2009 was something green weed or something bad. The NTF set up a sting operation similar to Catch a Predator on primetime, if you've ever watched that. They set up a bunch of cameras, and they call all of the delivery collectives, and when somebody shows up, they pop them. They say, you're under arrest, you're under arrest, you're under arrest, you're under arrest. Eugene Davidovich was arrested during that period of time. And these are people who are trying to provide medicine to patients. It'd be as if the DEA was going to pharmacies, going to Walgreens, and saying, I'd like to buy some OxyContin. and a licensed pharmacist in the state of California goes, here's your OxyContin. He goes, okay, congratulations, you're under arrest. I'm charging you federally. Well, wait a minute, what's going on here? There's a conflict of laws, and the people who are trying to enforce this law, the medical marijuana providers, are the victims here. Again, one thing that I'm fond of saying is that the law doesn't mean anything unless people do something with it. We could talk about the law. We could stand here and say, oh, well, there's this law. If I got a recommendation, I could use medical marijuana, but I'm too scared because of the feds out there. So therefore, the law doesn't mean anything. We've had a law for 15 years, and we don't have dispensaries in the city of San Diego anymore. They're gone. Again, the state law that we all voted for in 1996 is meaningless. It's void of value because law enforcement has imposed their agenda on patient access. And I have to say that that's what it is. In court every day, there is a small minority of opponents who are scared of the idea of medical marijuana. They frequently interact with law enforcement agencies because law enforcement agencies are scared of losing their jobs going after medical marijuana patients or marijuana users. These two exert an immense amount of influence on politics, and the truth needs to be told to politicians. We need to always remind people about the law, because we're here following the law. The Compassionate Use Act is the law, and again, it doesn't mean anything unless we do something about it. So 2008, Eugene was arrested. 2009, we had the 9909 raids. I don't know if anybody here remembers that, but that was a series of coordinated raids on 14 dispensaries throughout the county of San Diego. James Stacy, the nice-looking gentleman who's sitting over there at the table, was arrested for running a dispensary in Vista, and he was charged federally. So he was looking at 30 years in prison for running a medical marijuana dispensary. He fought the case, and ultimately he was given probation because there is no medical marijuana defense in federal court. Eugene fought his case. He was acquitted by a jury. Another gentleman by the name of Jovan Jackson was running a dispensary called Amsterdam. That was raided. It was raided in 2008 as well. He was acquitted by a jury. His second case, the judge denied him the defense, and that case is currently on appeal. Hopefully we'll get some law out of it. So we had 2009, 2010. 2011 was surprisingly quiet. We saw some federal raids that came kind of from other parts of the state, and it looked like 2011 was going to be a good year. It looked like that law enforcement was finally going to say, okay, we get it. We understand the law. We're going to lay off people who are using marijuana and growing it for medical purposes. Of course, marijuana is not legal for recreational purposes, and you can always still be arrested or detained and charged if you're growing or using or possessing marijuana for recreational purposes. However, since 1996, for 15 years, it's been legal for medical purposes. Yeah. The things that, so people then, and excuse me if I'm rambling, I'll have time for your questions. A lot of times people then ask me, well, how do I use marijuana legally in the state of California? How do I go about becoming a medical marijuana patient? What you have to do is you obtain a recommendation from a doctor. That can be written or oral. Most recommendations are written. And you go to a doctor who's a licensed physician, and he says, based on my professional opinion as a doctor, and again, this person has gone to medical school and is licensed to practice medicine, I believe that your illness or injury, based on my medical opinion, would benefit from the use of medical marijuana. You then have a recommendation or a card. You can use this to obtain and you have immunity from cultivating marijuana for medical purposes. Then
absolutely.
Another thing that happened in 2003 is what was called the Medical Marijuana ID Card Program. This is a state card, and it's a voluntary program. The purpose of that was to give law enforcement an easy way to identify who really is a medical marijuana patient. A lot of times medical marijuana patients are concerned because they say, well, I don't want to, I'm still uncertain that the state of California is going to be able to protect me from the federal government, so I don't want to get that card just yet. In case you're interested, it's $166. You have to renew it every year. You get it at the county administration building. You don't need that card to use, possess, transport, cultivate marijuana. The only thing that it gives you is it is supposed to be a get out of jail free card.
Yeah.
It is supposed to be a card that when you present it to law enforcement and you have a reasonable amount of marijuana, they must let you go. And that's what the law says. And again, I'm a lawyer, so I only generally learn about the bad things and the problems that happen. But I have heard more and more that law enforcement is respecting the law and letting people go when they have this card. So I'm hopeful that that's happening. I don't hear of that too many times because people only call me during the bad times. So that's the state-issued ID card. That is supposed to be a get-out-of-jail-free card when you have a reasonable amount. Again, so I guess then looking at the civil side of things, the regulation. So setting aside the criminal side, looking at the civil side, which is, okay, let's try and figure out how to have access to marijuana, because we know that these people have the right under state law to get it. And the question always becomes, well, where do they get it from? Because you go to your doctor, maybe you've never been around marijuana before, and he says, I think that you could benefit from this medicine. Here's your recommendation. And you go, okay, doctor, thank you so much for the recommendation. Where do I get it? Now, he can't tell you where. He says, good luck, figure it out. And so then you leave, and most people, I think, these days are under the idea of, okay, I'm going to go to a dispensary, a medical marijuana dispensary. Now, where that concept comes from is from 2003, when we were talking about this concept of collectives. So sometimes people say it's a collective, sometimes it's a dispensary. In January of this year, the word dispensary popped into the law, but before then, there was never the word dispensary ever used. Dispensary popped into the law this year when we banned them from 600 feet from schools. But before then, it had never been used. Really, the word that had been used is a collective or a cooperative. Under the Health and Safety Code in 2003, the legislature wrote this line. Qualified patients and primary caregivers may collectively or cooperatively may associate to collectively or cooperatively cultivate marijuana. That's it. That's the line that we have to figure out how to get marijuana. There's another health and safety code that says no individual or organization may profit from the sale of marijuana. So from those two sentences in the health and safety code, we tried to figure out what those two sentences mean. What we decided they meant is that patients may join a group, may associate, and the purpose of the group is to grow marijuana, because we know marijuana is grown somewhere. That's where it comes from. Grow marijuana, and that those people cannot make a profit. Now in Colorado, interestingly enough, they can make a profit, but not in California. In California, collectives must be not-for-profits, and individuals must be not-for-profit groups. So you have two principles on collectives. One, all the marijuana must be grown by patients and distributed to patients. It must be a closed loop of distribution. In other words, what that means, bottom line, is that the marijuana cannot come from the Mexican mafia and it cannot go to school children.
Good.
And generally, reasonable people support that.
Yes.
We want to support locally grown medical marijuana. We don't want to buy, well, we cannot buy medical marijuana from illegal drug cartels, and we cannot buy illegal marijuana from other states. It has to be within the state of California. That's what a collective is. A closed loop of distribution, and it doesn't make a profit. Does that mean that no money is exchanged hands? The Narcotics Officers Association would say yes. I think the vast majority of reasonable people would say no, including the Attorney General in 2008 by the name of Jerry Brown, who is now Governor Jerry Brown. He said that this concept of dispensary collectives, storefront collectives that exchange money, something of value, for medical marijuana, another thing of value, is perfectly reasonable under the law. So that's what a collective is. In 2009, really, after we started having these raids, the city of San Diego said, okay, we better figure it out. We better figure out where these people can get medicine, and we're going to enact zoning laws. And so there were a number of meetings. They formed something called the Medical Marijuana Task Force. Larry Sweet, who you heard speak earlier, was a member of that, as well as lawyers, members of law enforcement, clergy, politicians, teachers. All this group of citizens who represented the community said, we're going to get together and figure out how to grow and distribute medical marijuana in the city of San Diego. And they talked, and they talked. and they came up with ideas, and they had open meetings, and they had tons of ideas, and they wrote recommendations, which was great. It took a year and a half to get down the recommendations. And then they submitted them to the city council. And the city council said, okay, we're going to think about this some more. We're going to talk about it some more. We're going to send it to that committee, and then we're going to send it to that committee. And it dragged on and on and on. And in the meantime, there were more raids on dispensaries. Dispensaries were sued. There was basically no place to get medical marijuana in the city of San Diego. And then this past year, they passed an ordinance. It wasn't anything like what the Medical Marijuana Task Force suggested. It was much more limited. It was limited to very few parcels throughout the city of San Diego. It had security requirements, a fee requirement, but it was an ordinance. And most people, and this is kind of where it gets a little political, people have different opinions about this. I think that most people would have wanted an ordinance that would have worked. The problem with the ordinance is that it said all the dispensaries have to close and then reapply for a license. And I think the problem with that was that fundamentally people didn't trust the city council to actually give anybody a license, because they could pass an ordinance and then get what they want, everybody's closed, and then not give any licenses. They could come up with some reason for not giving a license.
Zoning.
Yeah, through zoning. It's too close to this, it's too close to that, we're not going to grant a license, not going to grant a license. And so then what happened is that the people, again, said, we don't think what you guys did was right. You guys formed a task force, we liked those recommendations, and you didn't enact any of it. So then the people of the city of San Diego gathered enough signatures, 40,000 signatures, and repealed that ordinance, which was, it was a good thing and a bad thing. It was a good thing because we didn't like it. The bad thing is that now there is no zoning and there's no law. And so now what's happening is the city attorney, Jan Goldsmith, is suing all of the dispensaries. And he's saying, you have to close because there's no law. There's no zoning, so you're going to fight us in court and we're going to sue you, and I hope you have hundreds of thousands of dollars in legal fees because we're the city of San Diego and we want you closed. So they're getting sued by the city attorney. Additionally, again, going back to the federal crackdown, which started October 4th and has since spread to other states, but it originated in the state of California, and there are many theories about how this started. What seems to be public from the U.S. Attorney's Office is that the 4 U.S. attorneys throughout the state of California got together and they said, for some reason, medical marijuana is a priority of ours. Now, we have lots of jobs as U.S. attorneys for the state of California. We enforce immigration laws. We go after, drug cartels. We go after sophisticated financial crimes. We do lots of really important things, which I think most of us support. But one thing that we don't think, at least most of the people that I think I talk to don't support, is the concept of the U.S. attorney prosecuting criminally or through threat of taking their property people who are complying with the laws of the state of California, or for any state for that matter. The guidance that we have to go on for the federal side are 2 memos. A lot of people are probably familiar with them. In 2009, the Deputy Attorney General by the name of James Ogden, who was writing this memo on behalf of Eric Holder, who was the Attorney General for the federal government, wrote this memo. He said, okay, in regards to federal law, we realize that marijuana is the same, we look at marijuana the same way as black tar heroin. It's a Schedule I substance. But we get that there are 16 states that have these crazy things called medical marijuana laws. And we don't want to waste precious federal resources. So here's what I'm advising all of my U.S. attorneys to do. Do not go after medical marijuana patients who are in clear and unambiguous compliance with state law. So it's not very clear, obviously, because like, well, how do I become clear and unambiguous compliance with this law that's pretty ambiguous? But at least it's something. And so from 2009, we saw a lot more medical marijuana activity throughout the U.S. and also in California, because they go, okay, thank you, President Obama. Thank you, Eric Holder. You wrote this memo that you're not going to target people who are following the laws of the state of California. And so a lot of people started getting involved, getting active, and like you heard Vay say, I think, coming out of the cannabis closet. Okay, it's been illegal for the last 30 years. But now here's the federal government saying that it's okay. Here's the federal government saying that as long as I follow the laws of the state of California, I can come out of the cannabis closet and tell my friends and family I'm a medical marijuana patient. And it's okay to say that because I'm not a criminal. In 2010, there was another memo, and it backpedaled a little bit. It said, oh, excuse me, in 2011, it was this year. And this was by an attorney general by the name of Cole. He sent out a memo and he said, okay, we changed our mind a little bit. It is a priority. We are going to go after people who are profiting from the sales of medical marijuana. And he didn't say anything about what that means exactly, but I think a lot of people throughout the state of California were still okay with that because they go, okay, that's fine, because we're all not for profit. So, you know, no one's profiting from this. We're just breaking even, if not losing money, distributing marijuana to medical marijuana patients. So that's still okay because we're not criminal profiteers. And then on October 4th, there was a press conference of all the U.S. attorneys in the state of California, all 4 of them, and they said, okay, we're going to target everybody in the state, all the medical marijuana patients and providers in the state, because we decided that it's a priority for us now. And here's how we're going to do it. We're going to do 2 things. We're going to raid. We're going to go after and arrest people who we think are the big profiteers, I guess. And we're going to write letters to all the dispensaries in San Diego specifically, and we're going to say, look, you have 2 options. You can either close in 45 days, or we may go after you. We may go after you criminally, or we may do something called what's known as an asset forfeiture proceeding. In an asset forfeiture proceeding, the government gets to take your property because they think that it is either being used or came from something that's illegal. So the U.S. attorney wrote these letters to all the dispensaries, and they said, okay, you guys better close because in 45 days something's going to happen. And nothing has happened yet, but again, it is my opinion that people should take these letters seriously because the risks are very, very serious. Again, for those dispensaries that are open right now, they are open at the threat of a raid by the DEA or a lawsuit by the Attorney General, the U.S. Attorney's Office to take everything that they own, and then to use that money to fund the DEA. It's called asset forfeiture. For example, last week I read a news article that the LAPD just got $1.2 million that they took that the DEA took from a dispensary. So that money, generally the local law enforcement gets about 80% of money that's seized by the federal government, and the state police, the state government can also initiate asset forfeiture. Because of course marijuana is illegal, it's only medical marijuana that's decriminalized for our purposes. So they and if you know any medical marijuana patients that have been raided or been arrested, this is pretty well known to everybody. Generally, medical marijuana patients characterize it as a smash and grab, similar to a robbery, where law enforcement comes in, they have a warrant, and they take money, they take cars, they take boats, and they say, okay, we think that you got this money or this car or this boat from selling marijuana, so we'll see you in court, because if you want it, you better have to prove where it came from. So this is what's going on. It is a war on medical marijuana. It is a civil rights movement because in the state of California for the last 15 years, medical marijuana patients have had the right to use, possess, cultivate, transport, and I believe purchase or sell medical marijuana. But the federal government doesn't respect that at all. It appears that the city and county government does not respect that at all. And we still are in a movement. Steve D'Angelo, who's the director of Harborside, who is now in the documentary Weed Wars, said about 6 months ago, he said, medical marijuana is not an industry, it's a movement. And he's absolutely right. We, for a couple of years, it seemed as if it was going to be an industry that could pay taxes, that could employ people, that could contribute to the community, that could be regulated. But it seems like we've gone back a little bit, that it's still a movement to show everybody that that there is a right to use this medicine, that there is science to support that. And again, I want to thank everybody for coming out and being part of the movement, because it is very important to the people who need it.
Thank you for your time. Thank you very
and if anybody has any questions, let me know. This is legal advice.
this is really medicine, how come you can't walk into a dispensary and say, I have a headache or a bad back, and get specific marijuana for a specific ailment? That's why it seems so phony.
Yeah, that's a great question. Okay, because a dispensary is not a doctor. A dispensary, I think, is more like a pharmacy. So I can't go to my pharmacist and say, I have a headache. What would you recommend? Or I have chronic pain. What would you recommend?
You can. Pharmacists tell you what's in it.
But they cannot prescribe. My dad's a pharmacist. The pharmacist cannot prescribe medicine. But that's an interesting point. Secondly, because marijuana has been illegal under federal law, now there is one way to grow and research marijuana under federal law, and that's if you're the federal government. There is one patent to conduct research on marijuana under federal law, and it's owned by the federal government. Last week we learned that the federal government may want to license that exclusively to one company out of New York. So you kind of figure, what's going on here? Well, what is it? Is it illegal or is it something to be researched? But another problem with with figuring out specific strains is that because it has been illegal under federal law, we lack data. There's a lot of data out there out of Europe and other places, but nobody has ever been able to conduct research. So so dispensaries were trying to do that and accumulate information and share information, but now they're all going away. Hopefully they'll save that information and share it. I mean, another interesting thing that comes up with that question is the names of strains, because Bubba Kush, for example, has been around for a long time. People are familiar with it for a long time, and people are familiar with what it does, probably both on the recreational side and on the medicinal side. So then, law enforcement then comes in and says, well, why is this medicine called that strange name? And it's an interesting conversation. Well, because somebody comes in and he knows this medicine, he knows this strain of marijuana, he's used it for the last 30 years, and if you change the name on him, he won't know what to ask for. So, it's a lack of information. It's two things. Somebody who's working in a dispensary, is trying to get as much information as he can about the efficacy of different strains. But again, there's so many hurdles. Other questions? Yeah. Yeah.
Why is marijuana illegal?
Why is marijuana illegal? I don't know. Good question. Why do you think it's illegal? Good. All right.
Because people that use it are labeled as dirty drug addicts.
Okay. Yeah, because there's a lot of stigma out there associated with it for recreational purposes.
I believe it don't start with marijuana. I believe it starts with cigarettes and alcohol. Right. Those are the gateways.
Okay, so opening up the conversation to why is marijuana illegal? I've thought about this a lot, and here are some of the things that I've come up with. Again, I don't know. I would like the world to work in a logical and rational way. What's that? How does the law get passed? It was passed by Congress in 1976 during the Nixon era.
What is it going to take to change it so we can get out of this?
All right. Well, let me just okay. How did you change? But here are some thoughts that I have. The DEA, law enforcement, okay? Again, we talked about asset forfeiture. Marijuana remaining illegal is a money-making enterprise for law enforcement. Again, anything that they get, that they seize, they get to sell and then fund for their jobs. Big Pharma. There is a product that's currently being tested called Sativex. Can't remember the name of the pharmaceutical that has the patents on it. But Big Pharma may feel that if, when medical marijuana is descheduled and really used federally and you get in pharmacies, that might get into their oxycodone, profits, or Vicodin profits. Alcohol, tobacco, and fire, or alcohol. It's a good question. People, again, marijuana is only decriminalized for medical purposes. But again, a lot of times, as we've heard today, a lot of people think that it should be decriminalized for recreational purposes as well, and that perhaps the medical marijuana movement will also spark a legalization for recreational movement. So then, if that's the case, then perhaps the alcohol industry as well. say, boy, you know, or the tobacco industry, boy, if that stuff is legal, people aren't going to go to, you know, that one or that one or that one or all up and down the street with all these liquor stores and saloons. Who knows? They could go to something like a coffee shop in Amsterdam, and that might take their profits down. I think a lot of things is money and power driven. So again, the question is, how do you change the law? You change the law by just being active and having faith in the democratic process and continuing to do things like this, getting active, coming to movements, writing your elected officials, writing letters to the paper, and just reminding people that marijuana is medicine and that medical marijuana patients are not criminals, they are normal people. And you hope that your elected officials will change the law because they are elected there to do that. How do they change the law? Very simple. They deschedule marijuana from a Schedule 1 to a Schedule 2 substance so it can be distributed.
Why should we have to prove something to somebody that has no we have to show them like why something like it's retarded, man. They have no reason why it should be a law, and we have to show our higher government why we should be able to use it. It's retarded. It really is. Like, we have like really no use for this law, and we're all fighting for this, and we have to show them why. Like, it's just like, I mean, I say fuck the government, and I think whoever made that law was retarded, dude. Seriously, man, we have to show the people that pretty much made a law for no reason. Like, it's really dumb.
Again, you know, I want to say that this is a movement, and we live in a time where you can lawfully possess and use and cultivate marijuana, which is at least a start.
Yeah.
You know, the gentleman with the OB rag was saying earlier, look, 1966, 1970, well, 1998, 95, if you were smoking a joint for medical purposes because you had cancer or rubbing a tincture on your body because you were covered with burns, you could go to jail for 3 years at a minimum. So we've come a long way. Again, there are 3 states next year that are going to consider medical marijuana laws. Call people in those states. If I remember correctly, I believe they are, oh man, I can't remember it off the top of my head right now, but look them up. So we're going there. We're getting there. Ohio is one of them. Yeah, what else? Do you remember the other 2? I don't remember.
I just know Ohio. I'm going home.
Oh, yeah, nice. Yeah, the guy who owns Progressive Insurance is funding the initiative in Ohio. So there you go.
And
You got the question over here? Yeah.
now legalization.
Well, you mentioned that you had done research on how marijuana is being held by the federal government. Do you know what I'm saying? I mean, until we clear it up, share the patent to allow others to research.
That's a great question. The question was, so the only patent held to research marijuana is held by the federal government. Is there something that other people can do to force them to share that information? I'm not a patent attorney, but I think that time has come and gone. Last Monday was the date to formally oppose the patent given through I believe it's the FDA. So it's kind of a mixed bag, that question there too, because you go, okay, well, what do we want? Do we want to say, we don't want you to give a patent at all, or we want you to give kind of, you know, I don't know, 2 or 3 patents, because if we just oppose it, do they go, okay, fine, no patent? And I don't know, that's something for policy, and that's for ASA and other advocacy groups to figure out. So, I don't know, that's a great question. It's a good idea. Yeah.
Could we sue the federal government for them causing us harm?
Can we sue the federal government for them causing harm? Great idea. I beat you to it about 45 days ago. In case you're interested, there was a lawsuit filed after the federal crackdown was announced, and it was a coalition of attorneys, collectives, patients, and property owners throughout the state. I handled the litigation in the Southern District, and we sued the federal government. It was very rewarding for me to serve the federal government, which is kind of interesting. It's got a 14th floor out of the way. It's really hard to find how to serve the federal government, but it can be done. And we filed lawsuits in all 4 districts. So the goal was to get a preliminary injunction, a restraining order, if you will, against the federal government from harassing, quite frankly, but really enforcing federal law to people who are in compliance with state law, exactly like they said they were going to do in their memo. So basically, it's forcing the federal government to do what they said they were going to do.
Yeah.
You know, you kind of wonder, why do we have to do that? But in any event, That lawsuit was filed. Unfortunately, the federal judges declined our request for restraining order. I think we got the most consideration here in the Southern District. We had a number of plaintiffs, including Congressman Brian Bilbray's daughter, Brianna Bilbray. And I want to thank ASA again for putting us in touch with her. That was great. She's a great spokesperson. She's a great role model. She's in her 20s. She went through a serious fight with cancer and used medical marijuana. Something that, like, oh my gosh, really? Crazy. You use medical marijuana. This thing has been around for 15 years. That's so crazy. And now she's talking about it. So it's great. In any event, the judges at the trial court level declined our request for an injunction, and we're preparing the appeal to the Ninth Circuit and then ultimately to the U.S. Supreme Court. So that's another way that you change the law, is you sue. So there we go. Yeah.